Hi, this is Kelsey Fagasi for AP Gov, and in this video segment, we're going to be looking at cases involving freedom of speech as well as the press, and we will be covering some of these required cases, and of course there are longer videos on my YouTube channel on these specific cases that are going to be detailed in this video. So, freedom of expression and speech, it's important that we distinguish with respect to symbolic speech, and by that we mean nonverbal communication. Keep in mind that all speech does not necessarily have to be verbal. You can convey your speech through specific actions such as burning a flag, wearing an armband, even having a particular bumper sticker could be symbolic speech there as well. So ultimately, this is generally protected along with verbal speech, and in a case, again, this is not required as per the AP Gov College Board for your test, but again, background context certainly will help you here. In Texas v. Johnson, burning the American flag is upheld and is seen as symbolic speech, and this was a very controversial ruling because it really puts patriotism versus free speech and expression up against one another. Now, this is considered free speech under the First Amendment, despite the fact that some states and local towns still have ordinances against burning the flag, but it is completely constitutional as per the Supreme Court. Now, at the same time, burning a cross is not protected because it intimidates. And I mean, if you were to put a cross on somebody's lawn, of course, because of the historic meaning behind that of intimidation, especially with the KKK, that would not be as protected. Now, when it comes to symbolic speech, a major case involving students, one that you are required to know for the AP Gov exam is Tinker v. Des Moines. And here you see the Tinker siblings here. They are protesting the Vietnam War, and they are wearing this armband, as you can see here, with a peace symbol. And they wear it to school, and they're ultimately suspended on the grounds that it could possibly create a disruption to the school environment. And this eventually goes all the way up to the Supreme Court, and the Supreme Court is going to rule in favor of the students in the sense because this does not interfere with the operation of the school. Simply wearing armbands is not disrupting the educational environment. Now, it's going to create a test for the lower court should they have similar issues, and this, of course, is known as the Tinker test. Does it interfere with the operation of the school? And if it does, the school can restrict that. Again, with respect to students' rights, they are dwarfed somewhat when they come into the school building, as the primary mission of schools is to educate. And so as a result, when you look at things like dress code, they are allowed to do that. Schools are allowed to, restrict certain things because if it creates a distraction to the operation of the school, well, then you're detracting from the education. So in this case, this was a big win for students' rights. Now, another case involving student rights is Hazelwood School District v. Kohlmeyer in 1988. And this is not a required case, but this involves prior restraint or censorship of a school newspaper. And as you see here, this is one of the newspapers, and this is a school-sponsored newspaper, and they're talking about articles that are involving pregnancy and divorce. These are very sensitive topics, and the school administration prevents it from being published. And once again, this goes all the way up to the Supreme Court, and the Supreme Court is actually going to rule against the students and saying that censorship is reasonably related to legitimate pedagogical concerns is allowed. So again, is this the place for students who are not experts on these topics and they're handling this stuff out? I mean, this should really be something handled by adults, especially when you're talking about pregnancy and divorce. So this is going to set a big precedent in the regulation of students' speech. So on the one hand here, with the Tinker case, this is a big win for symbolic speech. But on the other hand, when it comes to what you're allowed to write in newspapers that are school-sponsored, they are allowed to restrict you. Now, had they did this on their own, outside of school, with their own resources, they would certainly be well within their limits to do so. So, when evaluating the First Amendment, time, place, and matter regulations are very important. If there's going to be prior restraint or censorship or some type of restriction, it has to be content neutral. It cannot focus on one particular political viewpoint, for example, and it cannot suppress the content of the expression. In addition, if you're going to restrict something, it has to have some type of significant government interest. So, for example, in 1986, the Supreme Court is actually going to rule that burning a draft card was a disruption to the government's interest of raising an army. Think about how that could be a potential national security issue. It also has to be narrowly tailored. It cannot be broad and ambiguous so you can target anything in general. It has to be very specific if you're going to have a restriction. And you must be able to provide adequate alternative ways of expression if you were going to have this type of restriction. So there have been a lot of restrictions placed on the government in terms of if they are going to try to restrict your First Amendment, well, time, place, and manner are going to matter a heck of a lot. Now, when it comes to freedom of press, certainly, they have a lot of leeway. You have a lot of high-profile trials from O.J. Simpson, Martha Stewart, and that is completely allowed as trials must be held open to the public. And it's important to note that when we are dealing with the press is protected, depending on the state that you're in, by shield laws. And these protect the reporters from revealing their sources, especially when it involves important information that might be sensitive or the government doesn't want published, and they might try to compel the reporter to reveal his or her sources. A lot of states have developed these shield laws. However, speech can be limited when it involves obscenity. Now, there is actually no clear definition as to what that really constitutes, but for example, take pornography. A Supreme Court Justice Potter Stewart once said, with respect to pornography, I know it when I see it. So there's your definition as well. Miller v. California is going to state, out of a Supreme Court case, that materials were deemed obscene if the work appeals to a prurient interest in sex, if it was patently offensive in sexual conduct. Again, notice how some of these are very ambiguous, and lacks serious literary, artistic, political, or scientific value. So again, this is ultimately going to come down to community standards. What might be deemed as obscene in the South, where you have a more conservative culture, might be seen as permissible in New York City. It really depends, but it does come down to these local community standards. Now, when speech can also be limited is when libel is involved. That's when you have false or malicious statements that damage someone's reputation. Slander is the same thing, but it's spoken only instead of being printed. And another case that goes with this, with New York Times v. Sullivan in 1964, not required, but statements about public figures are libelous only if they are made with a reckless disregard for the truth. So the standard is much higher for public figures to prove libel and slander as opposed to private individuals. And as a result, you have people such as President Trump who are basically advocating for these libel laws to be tightened and making it easier for public figures to sue people who publish information that is not true. But as of the making of this video, it is very difficult for public figures, from celebrities to politicians, to prove libel and really, sort of prove that your reputation was damaged. Now, here's an obscenity example that you can read for yourself, but you can see, and if you're not familiar with Reverend Jerry Falwell, he's a very well-known evangelical minister, and you see in this particular example that the Supreme Court, even despite the fact that this is most likely patently false, the Supreme Court still ruled in favor of the magazine. So just showing you how high that level, that bar is to prove libel is very, very difficult. Now, when we talk about prior restraint, again, we are talking about censorship, and we see that there are certain instances, especially during wartime, where civil liberties and censorship tend to be, at one another. Civil liberties sometimes are being dwarfed while censorship is going up. And again, take, for example, this case, Schenck v. U.S. in 1919, right around World War I, and this socialist is distributing leaflets urging men to resist the draft during World War I. And the court ultimately rules that, yes, the speech can be limited because if it presents a clear and present danger, this is going to be known as the clear and present danger test, that can be essentially restricted. Sort of the classic example of the clear and present danger test is, assume you're in a movie theater that's crowded, and as a prank you yell fire or bomb, and people rush to the exits, and people are getting trampled upon and getting injured for no reason. your freedom of speech is not absolute, and so it can be restricted. You can't harass people, you can't threaten people, and again, if it poses a clear and present danger, there you have it. So generally speaking, it can be restricted, and that's what Schenck v. U.S. is going to rule, and this was used in a number of cases, and again, they create these tests for the lower courts should they have similar issues. Then on our final slide here with freedom of press, New York Times versus the United States in the era of the Pentagon Papers that are being leaked. And you have the New York Times as well as the Washington Post as well that are publishing these classified documents concerning how the United States got involved in Vietnam Wars along with some of the operations and very secretive information that the government did not want leaked. And so the government is trying to prevent this. However, the Supreme Court is going to rule that the government cannot prevent something true from being published, even if it was obtained illegally and conveys government secrets that could endanger national security. This is a significant boom for the freedom of press. Basically, this really prohibits prior restraint, even in cases involving national security. So, on the one hand, with the freedom of press, yes, you have it here, even if it's detailing government secrets and deals with national security. Yet if you look in 1919 in Schenck v. U.S., this is speech that's being limited. Now, it's important to note that this is 1919 compared to 1971, so certainly a lot of time has elapsed, and the clear and present danger test has sort of gone to the wayside, more or less, and there's been more of a to freedom of speech in the First Amendment in general in terms of utilizing prior restraint. We really don't see prior restraint being utilized in too many cases, but certainly it's important to know the New York Times of the U.S. as well as Schenck v. U.S. and Tinker v. Moines.